So hi, it's Gene Trowbridge from the Trowbridge Law Group, and this video is entitled 3 Words. 3 words you need to be aware of when you're working in the securities offering field to distinguish your offering between one that allows general solicitation and advertising and one that doesn't. So why am I talking about this? I'm talking about this because I'm the partner of a law firm called Trowbridge Law Group, and we do syndication and securities legal work. I was a former security syndicator, doing a lot of work in the self-storage business, actually. You can see that I had quite a few syndications, and at the height of my business, one year we sent out 1,676 K1s, and that represented about 850 different investors. Well, I'd always been a real estate broker. I've been a CCIM instructor for 40 years. I'm now a senior emeritus. And at some point, I went to law school. When I was 45, I said I'd had enough being a syndicator. I think I'll go to law school. I wrote a book. It's called Whole New Business. And I'm an old runner. Some of you who know me know that once I turned 60, I started running half marathons. And to this date, we've done 37 of those rascals. So that's it. And once again, welcome to our YouTube channel. And while you're here, don't forget to subscribe to our YouTube channel. So what we're going to cover today is we're going to cover the 3 words. They're sophisticated, pre-existing, and substantive. Those are the words you need to know what's going on. And how does it apply? Well, it applies here as we're looking at Regulation D, Rule 506B or 506C, as it works in your securities offering. Now, just to give you a scope of this, the most recent information from the SEC is that offerings under Regulation D that are private placements consisted of about $1.8 trillion in money raising during the last 12 months that they studied that. And that's 4 or 5 times more than Wall Street raised in what they call IPOs. Most of our offerings are similar to IPOs. They start out with nothing, we raise some money, and we buy something. It's the same thing. And most of our offerings are in real estate, although we've done racehorses and cannabis farming and intellectual property and solar panels. But most of the time, we're talking about real estate. And in Regulation D, the important part of Regulation D is if you do this correctly, you won't have to fully register your offering with the SEC, and you won't be subject to individual state regulations of what your offering looks like. The general rule is that any securities offering needs to be registered with the SEC unless it's exempt. Well, Regulation D offerings are exempt. And then Blue Sky or whatever the state laws are require you to take your offering into a state to get it approved before you raise any money, unless it's a Reg D offering. Reg D offerings are covered, meaning that they're preempted from state approval. So this is the best of all worlds, and this is where that $1.8 trillion is raised. And there are 2 choices when you go into Reg D that are used. One is a 506B, and one is 506C. Now, the structure of a 506B offering has been around for a very, very long time. And that structure is you can raise as much money as you want. You can have an unlimited number of accredited investors. Because you know those investors, they can just self-certify, check the box that they're accredited. We have a maximum of 35 sophisticated investors in a 506B offering, and there's no advertising allowed. And if you have one sophisticated investor, you're required to have a private placement memorandum. You go over to the other side, which is 506C, which just came to us. in September of 2013 from the Jobs Act. They said, Gene, I know you've been working under this 506 rule for quite a while, but we don't know how you're finding investors, and we don't know how investors are finding you. So we're going to give both of you, the investors and you, a bigger platform. And we're going to call it 506C. And what does it allow? It allows advertising and solicitation. So I could put my 506C offering on the web, social media. I could write articles about it. I could go on television or radio with it, and that would be fine. But some people are saying, well, I don't really want to do a 506C because in a 506C, I can only take accredited investors. And I don't want to do just accredited investors. I want to stay over here and use some sophisticated investors. So what do I need to do to protect myself so that I'm not considered someone who's been advertising or soliciting investors? Well, what you need to do is you need to follow and understand these three words. First of all, what is a sophisticated investor? A sophisticated investor would be one who's not accredited, okay? But it's one who alone or with the help of a purchaser representative, like a stockbroker or a financial planner, or by reason of their education, business, or financial experience, can be reasonably assumed to have the capacity to understand the fundamental aspects and merits of an investment in the company. So a sophisticated investor, whether they're using help or they're using their own knowledge, should be able to read the documents and understand the offering. If we're investing in multifamily, they should know something about multifamily. If it's self-storage, they should know something about self-storage. So we want to take sophisticated investors. They're not accredited. They're sophisticated, and so we can take them. And generally, the definition of accredited investors is $1 million of net worth or $200,000 of annual income if you're filing a separate tax return, or $300,000 of annual income, whether with you, your spouse, or your spousal equivalent. So if you're not accredited, how can you get in our 506B deal? You can get in there by being sophisticated. No bright line rules. There's no tests. There's no anything. It's just in your estimation as a sponsor. Can this person read the documents and make a decision on their own because they understand the merits, the fundamentals, and the risks of that offering? So sophisticated, and how we help you do that is the offering questionnaire we draft. We'll have a number of questions that an investor will have to fill out. If they haven't been able to check the box that they're accredited, now we have to take them through the sophisticated test. And we'll have questions like, have you invested in this type of an investment before? Are you using a registered investment advisor? What exactly are you doing? So sophisticated is one of the words. Now, as a defense against the charge of advertising or soliciting, because if you do a 506B and you do it right, you're exempt from registration and it's preempted from blue sky state registration. But if you do it wrong, now you should have gone back to the states. You should have gone to the SEC and register it. So we don't want you to blow your exemption or the preemption of your offer. So one of the things we'd like you to be able to do is, if you're ever charged with advertising, something goes wrong in the offering, investor gets an attorney, come to you and said, this investor never should have invested in that. They didn't know you. You advertised. They responded to a postcard. They responded to an invitation to a dinner. They read an article. They didn't know you at all. What they're trying to get to is you blew the exemption because of advertising and solicitation. So one of your defenses is by being able to say you have a pre-existing substantive relationship with the investor. And what does that mean? Well, that means that if you knew the investor before you started your offering or before you even contemplated your offering, that would be pre-existing. And if you knew something about the investor, which takes you really back to sophisticated, how do you know that they have the education, the support, and the wherewithal to understand the merits of the offering? You probably have to have a relationship with them, and they call that a substantive relationship. So the last two of the three words we're talking about are pre-existing and substantive. And you can see that that definition is right out of the SEC guidance booklet, so we might as well follow that. So pre-existing, the second of the three words. And in a relationship with an investor that has existed prior to the offering or even prior to the contemplation of the offering. Well, when is that? And I hear all sorts of people say, well, Gene, you have to know the person before you draft and get a signed letter of intent, an LOI. Well, I don't think that's the case, because even with the signed letter of intent, you could still buy the property yourself. You could wholesale the property to someone else, or you could walk away from the deal. So that really isn't an indication of the start of your offering. Another answer I've heard is, hey, the purchase and sale agreement. You should know the people before you get a signed purchase and sale agreement. Well, for the same reasons that the LOI might not be the start of an offering, a purchase and sale agreement might not be the start of an offering. You still could double escrow, or you could wholesale that property. You could buy it yourself, and you wouldn't have an offering. That's getting pretty close to when you have an offering. But at our firm, our answer is when you sign a fee agreement with the securities lawyer, now you're at least contemplating an offering. You sign the fee agreement, you pay your money, you get the documents from the lawyer, you go ahead, and the only reason you would do that is to go to the street with an offering. Now, when I was syndicating, I raised all my money through the broker-dealer community, through stock brokerage firms. And the stock brokerage firms had the definition of when an offering is contemplated, being that when I signed a selling agreement with them that was subject to their due diligence. They haven't done the due diligence on me or the project yet, but I signed a selling agreement subject to a successful due diligence program. And at that point of time, they told all their reps, okay, here comes an offering from Trowbridge. The only people that you have who can invest in this offering are people who you had in your database. You had a pre-existing relationship prior to the date that we signed the due diligence and the selling agreement. So I take that approach and say, okay, before you sign with an attorney, who knows what you're going to do? But the minute you sign with an attorney, I would think that you're at least contemplating an offering. And the rule is general solicitation and advertising cannot be used to sell an offering that you have or to sell an offering that you're contemplated. So let's just stick with that definition. Build your database, find your people, build your relationship with them. But once you sign a fee agreement with the attorney, I would say that part of your database freezes. You can continue to add people to your database, but the rule would be that they can invest in your next deal. Because one of the things that the SEC wants is they want to see you with a record-keeping system so that you can prove that the person who invested did not invest in an offering that was being offered the day you just met them, the day they responded to your website, the day that they answered your writing. Now, if you're advertising, you can't stop who you're advertising to. The whole world sees your advertisement. So what we need to do is we need to stop investors coming in that you did not have a pre-existing relationship prior to the date that you signed the fee agreement. So we're looking for sophisticated investors. We're looking for investors that you have a pre-existing relationship, and it has to be more than just having them in your database. I'm involved with quite a few groups that are out there, and there's a lot of education sessions going on, and you're walking through the audience and you're finding people's business cards. You take their business cards and you put them in your database. Your database probably has a date stamp as to when you put that record in there, so you can tell when the relationship started by that date. That's a good proof. And you can compare that to whether you had an offering on the street at that time. But as far as substantive, just having them in the database isn't it. This is quite a lengthy definition, but it's a relationship in which the issuer, the sponsor, has sufficient information to evaluate, and does in fact evaluate, the prospective investor's financial circumstances and sophistication in determining his or her status as an accredited or sophisticated investor. Self-certification alone, checking a box, without any other knowledge of a person's financial circumstances or justification or sophistication, is not sufficient to form a substantive relationship. Once again, from the SEC guidance. So up here it says, okay, we have a relationship with the issuer that's strong enough that we can evaluate the issuer's financial circumstances to figure out if they're accredited or not, and their sophistication as far as being able to determine what's going on in the offering and the relative merits of the offering. Down here it says self-certification alone by checking a box. Well, in a 506B, where you know everyone, you have a pre-existing relationship with them, and you say anyone who's accredited can invest with us, and they just check a box. That's fine. That's fine, because you know the people. If I was going to invest with you and I checked the box, you'd know me well enough to know that when I checked the box, I was telling the truth. Now, in a 506B, you really don't have any obligation to check farther than that, because I'm attesting to the fact when I check the box that I'm accredited. If I've lied, that's not going to be a very good defense for me, a very good argument for me when we go to court that I lied to you about being accredited. But so there is that box to check. There's also a box that says on the subscription agreement, hey, I'm sophisticated. But then we have a series of questions in the offeree questionnaire, which will go toward telling you that I am actually a sophisticated investor. I can understand the offering, and I can judge either alone or with someone else the merits of the offering and see if the risk is suitable to my situation. So what we have here is we have the words sophisticated, pre-existing, and substantive. Now you can read more about that in the fourth edition of my book. My book is called It's a Whole New Business, and it's available on Amazon. You just search the title, either my name or It's a Whole New Business, and look for the fourth edition. And it's available in hard copy or Kindle. So that would have more information about substantive, pre-existing, and sophisticated. So that's my video about the three words. I'm glad you joined us once again. This is Gene Trowbridge with the Trowbridge Law Group. Here's how you can contact us by phone or go to our website. If you go to our website and you want to talk about this, you can schedule a free 30-minute consultation. And once again, subscribe to our YouTube channel Trowbridge Law, because we have a lot of YouTubes that are very interesting and educational for you. I actually have a series of interviews that I call TLG Talks, Trowbridge Law Group Talks, with syndicators and other people who are supportive of the securities industry. And in there, you'll find all sorts of information about how people got started, how running their business is going today, and what successes and failures have they had. So that's it. This is Gene Trowbridge saying thanks for being with us.